Check. So good evening. We'll start with civil law 2024 forecast. Hopefully maraming makakita nito at maraming mag-like. I think siguro if I get like 100 likes in this video and probably several thousands of views, I'll make the CREM and REM version for day 3. Okay. Let's start. Civil law forecast. First question. Lingling hired Binicorp as a mess. Lingling, hired by Binicorp as a mess person on board MV Lagi, fell from a ladder while working and sustained injuries. The accident resulted in blunt head and back injuries along with a brain concussion. After the accident, he was taken to a hospital for initial treatment, then repatriated and referred to a company-designated physician. The physician examined Lingling and directed him to specialists for further treatment and rehabilitation. After weeks of treatment, the specialist and the company-designated physician cleared Lingling for work. However, Lingling sought a second opinion from another physician who declared him permanently unfit for sea duties. May Lingling collect moral and exemplary damages? The answer is no. Lingling may not collect moral and exemplary damages because there is no absence of malice, or because there is no absence of malice or bad faith in refusing the seafarer's claim for disability benefits. Moral damages are awarded as compensation for actual injury suffered and not as a penalty. The award is proper when the employer's action was attended by bad faith or fraud, oppressive to labor, or done in a manner contrary to morals, good customs, or public policy. On the other hand, exemplary damages are imposed not to enrich one party or impoverish another, but to serve as a deterrent against or as a negative incentive to curb socially deleterious actions, and may only be awarded in addition to moral, temperate, liquidated, or compensatory damages. Again, it may only be awarded in addition to moral, temperate, liquidated, or compensatory damages. In contracts and quasi-contracts, the court may award exemplary damages if the defendant acted in wanton, fraudulent, reckless, oppressive, or malevolent behavior. Based on the case of Scanfield Maritime versus Centeno. Another issue in this case is whether or not Lingling may collect attorney's fees. The answer is yes. The award of attorney's fees is proper because Article 2208, Paragraph 8 of the Civil Code provides that the attorney's fees may be recovered in actions for indemnity under workmen's compensation and employer's liability laws. Second question. Another question. Cole and Malloy owned a parcel of land. Mix, who had occupied the property since 1989, bought it from Cole after 5 years. They signed the deed of assignment in the presence of a notary public. Despite Mix's repeated requests, Cole did not surrender the owner's duplicate of transfer certificate of title, which prevented Mix from transferring the property into his name. Mix later discovered that Cole had mortgaged the property to Bini Banking. Mix claimed that he suffered actual damages due to the lost business opportunity he could have pursued had he been able to secure a mortgage on the subject property. Is Mix correct? No, Mix is not correct in saying that he suffered actual damage because the same was not proven with reasonable degree of certainty. Under Article 2199 of the Civil Code, it provides that except as provided by law or by stipulation, one is entitled to an adequate compensation only for such pecuniary loss suffered by him as he has duly proved, based on the case of Chinko and Chinko versus Shinko and Shinko. It's a 2022 case. Next question. Mixie died without a will, leaving behind his son Jolette. His other son Ian had died earlier but was survived by Derek. On July 17, 2003, Derek requested to be included in the distribution of Mixie's estate, claiming to be Ian's only child. He argued that both Mixie and their family's actions showed legal recognition of him as Ian's son. Ian had died before Derek's birth on October 9, 1978. Jolette opposed Derek's request. He argued that Ian never legally recognized Derek as his child during his lifetime and that Derek did not provide enough evidence to establish his filiation under Articles 172 and 175 of the Civil Code. Additionally, Jolette claimed that Derek's right to assert his non-marital filiation was already barred as Ian had died before his birth. He pointed out that even under the Civil Code, Derek failed to file a case for recognition within 4 years after he reached the age of majority in 1996. Can Derek still prove her filiation or his filiation? Yes, Derek can still prove his or her filiation because he or she was not yet barred from claiming her filiation. While he was not yet born when the family code took effect, she has the right to prove that she was her father's daughter under Article 285 of the Civil Code within 4 years from attaining the age of majority. Under Article 402 of the Civil Code, the age of majority is 21. Derek attained majority on October 9, 1999. She had until October 9, 2003 to assert her right to prove her filiation with Jolette. In this case, when she moved to be included in the distribution and partition of Mixie's estate in July 17, 2003, she was not yet barred from claiming her filiation. Next question. Prince stated that while his birth certificate lists his surname as Sevilleja, he has never used it and only discovered this fact in 2009. He was always been known as Prince Vergara. The certificate also shows his father's name, J.R. Sevilleja, who signed the document as the informant. When Prince renewed his driver's license in 2010, the LTO informed him that he needed to secure documents to officially change his name. This prompted him to file a petition with the Regional Trial Court. However, the Regional Trial Court rejected his request, citing concerns that changing his name could create confusion regarding his paternity or legitimacy. Is the RTC correct? The answer is no, the RTC is not correct because J.R. Sevilleja signed Prince's birth certificate not only as the father, but also as the informant. Despite the change in Prince's name, his father's identity remains on the birth certificate, where it will always be recorded and referred to in matters involving paternity. Changing a name does not alter or affect one's existing family relations or the rights and obligations that come with them. It does not change a person's legal capacity, civil status, or citizenship. Only the name is modified. Based on the 2021 case of Tan versus Office of the Civil Registrar. Next case. In 2003, Sheena filed a petition to nullify her marriage with Sherwin, from whom she had been separated since 1999. While the case was ongoing, Sheena gave birth to JR, naming Paning as the father on the birth certificate. After the court nullified the marriage, Paning sought judicial approval to voluntarily recognize JR as his child, but the RTC denied this petition. The court stated that the petition was contrary to the presumption of legitimacy and the best interest of the child. Is the court correct? Yes, the court is correct because the petition would impugn the legitimate status of JR collaterally, contrary to the family code, which requires direct action to impugn a child's legitimacy. Article 164 of the family code provides that children conceived or born during the marriage are legitimate. This means that legitimacy as a status attaches when person is born within wedlock. There is no dispute that JR was born before the marriage between her and Sherwin was voided. Thus, JR is deemed born within wedlock and is considered a legitimate child. Next question. Ling Ling is a child born during the subsistence of a marriage of Macolette and Josie. However, Ling Ling is not the biological child of the father, Macolette. Can Ling Ling still file an action to establish filiation? The answer is yes. Ling Ling can still file an action to establish filiation. Article 164 of the Family Code assumes two things. First, that the child was born during the subsistence of a marriage, and second, that this subsisting marriage is the marriage of their parents. The reality, however, is that a child can be born during the subsistence of a marriage, but not necessarily that of their biological parents. Nonetheless, children born under similar circumstances would be legitimate, but doubts as to their filiation and identity will persist. The concept of legitimacy is a civil status established if the person is born during the subsistence of the marriage. Filiation, on the other hand, is the relationship, the state of being one's offspring. It is determined mainly by biology. It may be the law that solely declares who are legitimate children, but in no way can it alter blood relationships. For this reason, children should be allowed, as the law allows them, to establish their filiation, notwithstanding the presumption of legitimacy, as legitimacy and filiation are conceptually distinct. Based on the 2023 case of Kua versus Republic. Next question, next case. Loima owned a 5,599 square meter parcel of land in Misamis Oriental during his lifetime. After his lifetime, his children took possession of the land and made improvements, though they left the property undivided. Later, they discovered that their father had another heir, Letko, whose daughter Jo sold her claimed share of 3,644 square meters to Nashi, making Nashi a co-owner. Nashi then ordered a stop to further work on the lot, build a fence, and posted a no trespassing private property sign. She also demolished 2 houses and pruned the plants on the property. In response, Loima's heirs filed a complaint for forcible entry against Nashi. May the heirs file an ejectment case against a co-owner? The answer is yes. The heirs may file an ejectment case or ejectment suit against a co-owner because it is a right given under Article 487 of the Civil Code. The co-owner may file an action under the law not only against a third person but also against another co-owner who takes exclusive possession and asserts exclusive ownership of the property. Based on the 2022 case of Mabalo versus Babuyo. Next question. In 1970, the Department of Education built Gandang Keratin Elementary School on a parcel of land in Apari, Cagayan. On June 19, 2008, the Recalde family filed an action publiciana against DepEd to reclaim possession of the land which they claim to own, as indicated by the transfer certificate of title in their name. The Recalde family asserts that they only permitted DepEd to construct a temporary structure for classrooms on the property. Question: can the court pass upon the issue of ownership in this case? Answer: as a general rule, the court cannot pass upon the issue of ownership. However, where the parties raise the issue of ownership, the courts may pass upon the issue to determine who between the parties has the right to possess the property. This adjudication, however, is not a final and binding determination on the issue of ownership. It is only to resolve the issue of possession, where the issue of ownership is inseparably linked to the issue of possession. The adjudication of the ownership issue being provisional is not a bar to an action between the same parties involving title to the property. The adjudication is, in short, not conclusive on the issue of ownership based on the 2022 case of Republic versus heirs of Ontiveros. Next question. Spouses Mecaya bought a parcel of land from the heirs of the late Stacyu, represented by Tintin Robles. The property is registered under the OCT at the Registry of Deeds for the province of Catanduanes. Since the sale, spouses Mecaya have openly and peacefully possessed and managed the property without any opposition from the heirs for over 40 years. They have also paid real property taxes. The assessor's office records clearly show that the property's possession and administration is under the spouses Mecaya. Question. Can the spouses Mecaya register their adverse claim on the title? The answer is no. Spouses Mecaya cannot register their adverse claim on the title because Section 70 of PD 1529 also only allows for adverse claims when there is no other legal provision for registering the claimant's interest. Since Section 68 of PD 1529 addresses claims based on implied or constructive trust, the spouses Mecaya must first use this option or this provision. They need not file a sworn statement with the Register of Deeds. They need to file a sworn statement with the Register of Deeds detailing the land, naming the registered owner, and referencing the certificate title number. An adverse claim under Section 70 is not applicable because there is already another legal avenue for registration. Additionally, Section 47 of 1529 stipulates that registered land cannot be acquired through prescription or adverse possession. Therefore, registering an adverse claim will not affect the property or its title, based on the case of Alberto versus heirs of Panty, a 2023 case. Next case. Aya, who was born with a physical disability known as lumpo, could not attend school or learn to read and write. After her mother passed away, her aunt Baloy took custody of her. At the age of 64, Aya sought Christine's help to prepare her will. Christine read the will to Aya and explained its contents and consequences in the presence of 3 notarial witnesses. Christine confirmed that with Aya that she understood the document. She then had Aya sign it, leaving all her properties to Baloy. After Aya's death, Baloy passed away, and Juwon, Baloy's adopted child, filed a petition to probate Aya's will and to be appointed as the estate's administrator. Aya's half-sibling opposed the petition, claiming that the will was defective because it was not read twice, once by a witness and once by the notary public, as required by Article 808 of the Civil Code. Question: is the will valid? Yes, the will is valid because it complied with Article 808 of the Civil Code. Attorney Christine read and explained the contents of the last will and testament to Aya. The notarial witness listened and understood Attorney Christine's explanation. Aya did not deny or correct what she heard. Although a Supreme Court case extended the application of Article 808 to cover both the blind and the illiterates, it also recognized an exception: substantial compliance. In this case, substantial compliance applies. The purpose of the law is to protect the testator from fraud and trickery, but it should not be applied so rigidly that it undermines the testamentary privilege. Based on the case of Gia versus Cosico, a 2021 case. Next case. The Philippine Reclamation Authority, PRA, has amended its joint venture agreement with Binibay Corp, formerly known as Amari. Under this agreement, Binibay Corp will develop 3 reclaimed islands, collectively known as Malaya Islands, covering a total titled area of 157.84 hectares. The JVA grants Binibay Corporation ownership of 77.34 hectares of these islands and 290.156 hectares of submerged areas in Manila Bay. Is the joint venture agreement valid? Answer: the joint venture agreement is valid because it attempts to transfer 77.34 hectares of the Malaya Islands to Amari, a private corporation. This transfer violates the joint venture agreement is invalid because it attempts to transfer 77.34 hectares from the Malaya Islands to Amari. This transfer violates Section 3, Article 12 of the 1987 Constitution, which prohibits private corporation from acquiring any alienable land of the public domain. Additionally, the JVA seeks to transfer 290.156 hectares of submerged areas in Manila Bay to Amari, or Binibay Corporation, contravening Section 2, Article 12 of the 1987 Constitution, which bans the alienation of natural resources other than agricultural lands of the public domain. Based on the case of Central Bay Reclamation versus Commission on Audit. Next case. Colette, a naturalized American citizen, executed a last will and testament in California, naming her cousin Sheena as the special independent executor for her assets in the Philippines. After Colette's death in California, Sheena filed a petition to validate the will in the Philippines. However, Colette's sister opposed the petition. The court found that Sheena did not present a copy of the relevant California law, and the petition did not meet the requirements of Philippine law. Question: is the will executed by Colette in California valid and can be allowed in the Philippines? Answer: the Philippine courts cannot admit Colette's will executed in California because it lacks the proof of compliance with California law. According to Article 816 of the Civil Code, an alien's will executed abroad can be valid in the Philippines if it meets the formalities of the place where it was executed, the testator's country of citizenship, or Philippine law. Again, if it meets the formalities of the place where it was executed, the testator's country of citizenship, or Philippine law. Colette, an American citizen, executed her will in California. Therefore, the courts need to verify that her will follows California's legal requirements. Since no evidence of California law was provided, the Philippine courts cannot validate the will. Based on the case of in the matter of estate of Aida Bambao, Linda Kaxkar versus V. Sequito Jr., a 2020 case. And next one, on September 10, 1992, Recalde sold his 1/4 undivided share of a parcel of land which was jointly registered under Vergara, Recalde, Arceta, and Apuli to spouses Robles. After receiving full payment, Recalde and spouses Robles executed a deed of absolute sale dated July 13, 2001. Vergara did not become aware of this sale until she sought assistance from the barangay through a conciliation proceeding. During this proceeding, Vergara attempted to redeem the property, but the spouses Robles refused to provide a copy of the DOAS or its details. Recalde eventually gave Vergara a copy of the DOAS on September 26, 2007. Vergara filed a complaint for annulment of sale and redemption with the RTC on October 16, 2007. The spouses Robles argued that Vergara's attempt to redeem the property occurred beyond the 30-day period required by Article 1623 of the new Civil Code, rule on the claim of the spouses Robles. The claim of spouses Robles is not correct because they failed to provide Vergara a notice of sale. The court has established that a selling co-owner must provide a written notice of sale to the other co-owners, even if they are aware of the sale. This requirement removes uncertainties about the sale's details and validity. Actual knowledge alone does not start the 30-day redemption period unless it includes all necessary information. The redemption period under 1623 began when Vergara received the deed of absolute sale on September 26, 2007. Vergara filed her redemption complaint on October 16, 2007 within the 30-day time frame, thus properly exercising her right. Based on the case of Rama and Rama Lauron versus spouses Norga and spouses Rama. Next case. Hambebe and Josie established Metro Bini Corp and took out loans from Westmont Bank, documented through promissory notes. In 1995, Hambebe executed a real estate mortgage to secure one of these loans, covering their joint properties. Josie later alleged that someone forged her signature on the loan documents and sought to nullify the real estate mortgage and its amendments. The trial court ruled that the real estate mortgage and its amendments were void, rendering the promissory notes legally ineffective for Josie. Will the nullified deeds of mortgage affect the validity of the promissory notes? The answer is no. The nullified deed of mortgage will not affect the validity of the promissory notes because the former is merely an accessory agreement and will not affect the principal contract of loan. This means that the promissory notes are mere accessory agreements and will not affect the principal contract of loan based on the case of Strongfort Warehouse Corporation versus Remedios T. Banta, a 2020 case. Last case. Chow Long borrowed 1.4 million from Bini Bank to boost the working capital of her general merchandising business. She secured this loan with a real estate mortgage on a parcel of land. Later, she amended the real estate mortgage multiple times to increase the loan amount. Each amendment included a blanket mortgage clause, which specified that the real estate mortgage would cover not only the initial loan, but also any future obligation. Bini Bank has now filed a petition to foreclose with the regional trial court, claiming that Chow Long took out 5 million pesos in additional loans, covered by 8 promissory notes. Chow Long contends that the real estate mortgage not only secured the original loan and does not cover the subsequent 5 million pesos in loans. Question: does the blanket mortgage clause in the latest amendment to the real estate mortgage cover the 5 million succeeding loans? The answer is no, because a mortgage with a dragnet clause or a blanket mortgage clause does not automatically extend to cover future advances. However, when the document for the subsequent advance specifically references the mortgage as security, then the contrary applies. Without this clear reference, or if there is no supporting evidence, the mortgage will not cover the new loans. Jurisprudence upholds the validity of dragnet clauses, but their terms require careful scrutiny. In a particular case, foreclosure proceedings were invalidated because there was uncertainty whether the promissory notes were secured by the mortgage. The promissory notes did not indicate that they were covered by the mortgage or reference the mortgage as security. Furthermore, the latest amendment to the mortgage could not be interpreted to cover the subsequent loans under the promissory notes, based on the case of Kembao versus China Bank, a 2021 case. And that's it. Thank you and good luck, everyone.